Hello and good afternoon. I would like to welcome everyone to today's webinar and the second in our ongoing series, H-1B Cap Prep Part 2, 6 Ingredients for your H-1B Cap Petition. First, I would like to go over a few housekeeping items. This webinar is being recorded and we will send you a link to download the recording after today's live session. You'll also be able to download the accompanying slide deck. So please keep an eye out on your email inboxes in the coming days for those links. We also encourage you to ask any questions you may have throughout the presentation. So please do so, and we'll get to them in the middle of the presentation and at the very end as well. And so if you would like to ask a question, please do so using the question function on the right-hand side of your screen. Okay, so for those that are unfamiliar with Envoy, for nearly 20 years, Envoy has been on a mission to fix the frustrating, confusing, and inefficient immigration process. Envoy combines expert legal representation with innovative technology to deliver the only platform that makes it seamless for companies to hire, mobilize, and manage a global workforce. We secure work authorization in over 150 countries. I've grown 46% year to date and work with over 1,000 customers. We are particularly proud of our NPS score, which is a testament to the employee experience that Envoy provides. And now I would like to introduce today's presenter. Natalie Z is an associate at Global Immigration Associates. She graduated from IIT Chicago Kent College of Law in December of 2014. And while in law school, Natalie gained experience in immigration, workers' compensation, and personal injury law. Natalie graduated summa cum laude from St. Xavier University in 2011, earning a bachelor degrees in political science and history. She is licensed to practice in Illinois and is a member of the American Immigration Lawyers Association and the Chicago Bar Association. Natalie was born in Poland and is fluent in Polish. Natalie, thank you so much for joining us today.
It is my pleasure. Thank you.
Great. So before we get to, I know quite a few individuals are familiar with the H-1B process, but I would also like to kind of gauge our audience today. I'm going to run a poll really quick. So in a few seconds, you're going to see a poll come up on your screen. And we'd love for everyone to participate by choosing one of the answers. All right, so on your screen, we're just curious how familiar people are with the H-1B Cap process. I'll give about 10 more seconds for people to respond. All right, thank you so much. So, it looks like a majority of our audience today, you guys are familiar with the H-1B Cap process, but would like to expand that knowledge. And that's where we hope you'll find today's webinar informative. Hopefully, we'll answer all your questions and help you guide you through the H-1B Cap process. So as you'll notice in our agenda, as soon as I switch the slide, we have the 6 ingredients that will help you with that H-1B Cap process, which I will now turn over to Natalie, and she can take over.
All right. So during this webinar, we will discuss the importance of starting the process early, the labor condition application, or the LCA, tips on perfecting the H-1B petition, site audits, the advantage of technology in the process, and the benefits to your employees. The first ingredient here is starting early. Starting the H-1B process early is highly encouraged, especially under today's uncertain immigration climate. Naturally, we are encouraging that policy, and we are opening H-1B Cap cases as early as November this year. Opening the case well in advance of the H-1B filing season allows employers to first thoroughly discuss your case with your attorney. Each case is different, and the attorneys should know any special facts that you have to offer for your position and employees. Second, it will allow us to gather all necessary documents from both the employers and the employees. In cases where additional documentation is required, allowing yourself extra time to gather the documents is very beneficial. This is particularly helpful in cases where specialized evaluations or translated documents are required. And third, this will provide sufficient time to review the case for accuracy and correctness. Additional time always allows the employers and the attorneys to review the case, ensuring that the key components of each case are prepared correctly. Lastly, and probably most importantly, starting early gives your employer and the employee a peace of mind. The H-1B Cap season can be particularly a stressful time. Knowing that your case is prepared timely certainly takes some pressure off. One of the most important parts of the H-1B petition is the labor condition application, or the LCA. This application must be submitted to the Department of Labor and certified by the Department of Labor prior to your H-1B submission. Generally, the LCA process takes 7 to 10 days. However, during the H-1B Cap season, this may take longer due to higher workloads. As such, we encourage to file the LCA on or before March 1st. Prior to filing of the LCA, we must determine crucial information about the H-1B petition and the position that is being offered to your foreign national. We will be required to determine the Department of Labor classification of the position that is being offered to the foreign national. This is achieved through an evaluation of the position title, job description, and the duties of the job requirements. We will also be required to determine if the offered wage for the position are within the prevailing wage designated for the geographic location of your work site. Given these requirements, it is crucial that employers provide detailed job descriptions and duties for each H-1B position and applicant. Lastly, we also have to ensure that your employees are notified of your intention to file the LCA, either through physical posting at your job site or primary place of business, or through electronic notice. Our third ingredient is perfecting the H-1B case. The first step to this is gathering sufficient documentation. Each party of the process is required to provide certain documents. As an employer, you're required to provide documentation that establishes that you are an operational entity and you are able to provide your H-1B specialty occupation to the employee. This can be demonstrated through materials demonstrating the nature of your business, such as website information, marketing brochures, as well as documents describing the proposed employment, such as detailed job descriptions, an offer of employment, or a contract.
Natalie, we actually just got a question that came in. So as you see, one of the requirements is marketing collateral in those brochures. So individual wants to know, what makes a strong piece of marketing collateral?
A good marketing material will clearly explain the work that your business is performing, your possible financial growth or financial strength, explain the projects that you're working on, and discuss the clients that you're working with or working for. The key for the employer is to show that you can sustain employment for the foreign national and for a period of 3 years or whatever is the requested period. This can be demonstrated through proof of how sophisticated you are in the field, your growth, your workspace, and availability of clients and work product for that employee.
Great, thanks.
So additional documentation that you may provide that you are not required but encouraged, particularly for new businesses or first-time H-1B filers, are taxes, annual reports, financial statements, any state or federal filings, pictures and blueprints of your work site, and information about your clients. This is particularly important if you are offering end client work or work at multiple work sites. Foreign nationals are required to provide the documentation as well. They have to show that they qualify for the H-1B position. This is demonstrated through their credentials, through their diplomas, and relevant transcripts. If those documents are not originally in English, they must be translated and certified, which adds to the prep time of the case. And if the foreign national earned his or her degree outside of the U.S., they will have to obtain a foreign credential evaluation that will equate their education to an equivalent degree from a U.S.-based institution of higher education. If the foreign national does not have at least a bachelor's degree, or his or her foreign degree does not equate to at least a U.S. bachelor's degree, the foreign national may also need to obtain an evaluation of education, experience, and training. that will result in an equivalent of a U.S. bachelor's degree. The process of obtaining necessary evaluations is a significant reason behind starting the process early, as this alone can take a few weeks. The foreign nationals who are presently in the U.S. must also show, through documentation, that they are maintaining valid status in the U.S. This is demonstrated through their Form I-94, which is granted upon every entry in the U.S., and any current visa stamps or approval notices indicating their current status. If the foreign national is a student, which is very common in first-time H-1B filings, they will need to provide their valid Forms I-20 and any employment authorization documents, or EAD, issued in relation to their optional practical training, or OPT. If the foreign national is currently working under a different work visa or under EAD, they will have to provide their recent pay stubs as well. The key to maintaining status is being able to provide that the foreign national has valid and unexpired visa. This could be most commonly an F visa. Another crucial step in the perfecting of your H-1B case is the job description. A successful job description will consist of at least 8 detailed and specific job duties that indicate the performed activity and the tools, skills, and technologies used to perform those activities. Each job duty should reflect the specialization of the offered position. If you take a look at our slides, you will find a great example of what a detailed job description looks like. Here, when you're trying to convey that the position will develop high-quality software for our business, what you can say is utilizing technologies including Java, Ruby, and Python to develop software to automate companies' shipment and tracking platform. The following job duty goes into specific and technical detail that includes the special tools and skills used to perform the job duty. This is very important in H-1B cases. Providing detailed job duties will not only allow us to classify the position for the purposes of filing the LCA, as mentioned earlier, it will also convey that your H-1B case classifies the specialty occupation position, which is an H-1B requirement. Providing job duties that clearly reflect the position that you are offering to the foreign national requires a theoretical and practical application of a body of highly specialized knowledge, will increase the success of your case and decrease the chances of a request for evidence. USCIS will first review the job duties of the position to determine if the position is in fact specialized. Another concept that increases your likelihood of approval and decreases your chances of denial is ensuring that your job requirements align with what is normal and ordinary for this line of work. Requiring a chemical engineering degree for a software engineer will not result in a successful case. As such, drafting careful job requirements, particularly educational requirements, that align with your business necessity and the actual field helps in perfecting your H-1B case. Further, setting wages that accurately reflect the offered position and the job requirements of the position will benefit your H-1B case. The Department of Labor assigns geographic prevailing wage to different job classifications. The Department of Labor also separates the prevailing wage into different tiers or levels based on the experience level required by the employer for the position. Selecting a prevailing wage level that accurately reflects the job requirements will increase the success of your case and will likely prevent an RFE or a denial related to wages. And lastly, employers who utilize multiple work sites or end client work sites should prepare to provide detailed itineraries of work and client letters and statements of work in their initial H-1B filings. These documents should contain detailed job duties, nature of the work performed, work site locations, requirements of the position, information about supervisors and employees' control over the employee, as well as the duration of the assignment or assignments. This is particularly important when attempting to secure an H-1B petition granted for a full requested duration of stay, which is ordinarily 3 years. Now, shifting gears to site visits. Site visits may be a reality to any employer of an H-1B employee. Site visits are designed to confirm that the employer is compliant with the Department of Labor and the visa requirements. Being prepared for the site visit gives you the best chance of a successful site visit. Your preparation should include two main items. First, the designation of at least 2 points of contact within your company for USCIS site visits. The employee who is coming first into contact with visitors, such as front desk employee or a receptionist, should be aware of your points of contact so that he or she can alert the points of contact right away in case of a site visit. And the second key to preparation is practice of proper document storage. As an H-1B employer, you are required to prepare and make accessible to the public a public access file for each employee that you file an H-1B and an LCA. You're also required to retain your public access file for a period of 1 year beyond the date of the employment under the LCA. If you file an LCA valid for 3 years, this means that you will have to retain your public access file for 4 years. The public access files must be stored physically at your principal place of business or actual location of employment, like a work site, or electronically, as long as they are made accessible. During an actual site visit, you should be prepared to first alert your point of contact, second, alert your attorney, and third, make contact with the actual USCIS officer. You should collect his or her name, business card, and the name of the employee in question. This will allow you to confirm that the H-1B employee in question is on site, review their case with your attorney over the phone or in person, allowing the time, and discuss any necessary strategy or steps for this case with your attorney. Once prepared, you'll be ready to meet with the USCIS officer in a private conference room or area. The meeting should include the employee in question and your point of contact or points of contact. Please know that your attorney may be present over the phone or in person if necessary. You should always take notes about your site visit and never attempt to answer questions when you are not certain of the answers. USCIS officer may ask you to answer questions and present documentation. You should be prepared to discuss the nature of your business, the length of your organization's existence, other work sites and locations, number of your employees and H-1B employees, number of employees working off-site, information about your end clients. You should also be prepared to discuss the nature of your H-1B holder's employment, which includes qualifications like educational requirements, salary, job duties, and who is responsible for paying of the H-1B filing fees. As such, it is essential that your H-1B documentation is easily accessible so that you are able to correctly answer these questions particularly about employment and the wages. Other than the public access file, the officer may request documentation from you or the employer, such as W-2s, pay stubs, and identification. If your site visit results in noncompliance, an employer may be fined and barred from hiring all or certain H-1B employees, which is a serious consideration. Further, USCIS may revoke the H-1B in question, leaving the employee without immigrant status and you without an employee. With a recent policy update, site visits by USCIS are on the rise, and employers should be prepared for this reality. This is particularly the case for employers hiring off-site employees or hiring in multiple work sites, employers who hire more H-1B employees than U.S. workers, and newer entities on which USCIS cannot gather sufficient business information through public accessible information. And on this somewhat gloomy note, we can discuss how technology can assist in the H-1B process, including in the site visit preparation. The use of technology can assist you with common challenges of the H-1B process, including keeping timelines and ensuring that your case is prepared on time. Missing the H-1B Cap season is the last thing that you or your employer need. The H-1B Cap historically closes during the first week of April. This means that if you cannot file your case timely, your employee will not have another opportunity for an H-1B visa until October of 2020. Missing an H-1B cap due to technology issues can often result in a loss of immigrant status for the employee and loss of valuable employees to the employers.
Great. And now this is where I want to build off of what Natalie just mentioned with how technology can really help companies, small, medium, large, throughout the H-1B Cap process. So as you see on this screen, without technology, there are certain aspects that can kind of, make things a little bit more, bog things down a bit. For instance, lengthy attorney interviews. Often it's not unheard of to be on long conference calls or traveling miles to an attorney's office. But with technology, such as Envoys, there are quick online questionnaires that are tailored to government forms that remember past responses, and those will fill out automatically. That saves you hours in a week and then hours that you can put towards something else. Additionally, it's not unheard of to email, fax, and overnight documents, at which point you have to kind of coordinate with the mailing service. But again, as Natalie mentioned, it really helps to kind of upload documents in a secure environment and ones that have multi-factor authentication. With those uploads are nearly instant, and then you can easily view them. Another benefit of technology is just the response time. There's no more waiting days, weeks for an email that may get lost in your inboxes. Instead, you can with technology. You can talk to the attorney with a faster response time. And then moving on, again, having that centralized place for uploading documents will help you throughout the H-1B Cap petition process, excuse me. Security, make sure that there's two-factor authentication, cloud security network that's backed up on multiple global sites. You want to keep everything safe from prying eyes and ensure that there's no loss of information. Additionally, flat fees. With technology, the costs. There are no hidden costs. And then transparency, just knowing where everything stands and with communications with the attorneys, and you just avoiding the emails getting lost in the shuffle. And again, those questionnaires can help you save hours per week by not having to do those mundane tasks. And ultimately, this all can conclude by improving the employee experience. Starting the H-1B Cap process early can give employees and yourself extra confidence and help improve that H-1B Cap petition and then, again, the employee experience. You'll provide employees with peace of mind. You'll understand the H-1B Cap petition requirements and not rush. And then you'll also increase transparency because, again, with technology, employees can easily communicate and yourself with the attorneys. There are no more emails lost in the shuffle. So, Natalie, before we get to the questions, is there anything else that you would like to add regarding the H-1B Cap petition process?
Sure, we can just add a little bit on how important your employee experience is. Combining an early start and the technology can greatly improve that experience for your employee process. Starting early, as mentioned earlier, can provide your employees, who are likely the most stressed parties involved here, with assurance and that peace of mind, which is very important. While technology gives your employees transparency and ease of communication, it also helps them prepare. Technology allows the employees to easily communicate with attorneys and staff, which is very important, as this allows them to talk about the case, the progress, any outstanding requirements and documents, next steps, and any other case matters. This allows the employee to know or access their case status at any time, which is very assuring, and it will certainly take some pressure off of you from receiving all questions about that. Technology also provides that ability to share documents easily, review the documents, and upload them. If at any point during the case processing a document is required, an employee is able to provide that document quickly and easily, which makes everyone's job easier. And the employee can also be alerted instantly when a document is required. And with that ease of process, there's transparent communication for the employees, and the peace of mind, your employees should have a very positive experience with the H-1B Cap.
Great. And with that, we're going to open up the floor to some questions. But I do see on your screen there are some education credits that you can use. If you would like to ask a question again, please do so using the GoToWebinar panel that you should see on the right-hand side of your screen. So with that, we're going to just get right into it. So, Natalie, first question. Is there time to, the attendee wants to know, is there time to catch up? It seems like I'm behind.
Well, luckily right now we are still very early in the process. The H-1B Cap petitions do not have to be submitted until April 1st. And as mentioned earlier, we do not require to file the LCA until the end of February, beginning of March. So there is certainly time to still catch up. The sooner you open the case, the better. But the standard processing time of the case shouldn't take more than 1 month. So you are able to open the case for still some time.
Great. You mentioned that there are a list of required documents that you need to submit early on in the H-1B Cap petition process. What happens if USCIS rejects one of those documents?
If USCIS does not deem some of the submitted documents as sufficient, they will issue an RFE, which is a request for evidence. Ordinarily, as an employer, you are permitted 30 to 83 days to respond to that request for evidence with any additional documents. So if USCIS does not believe that the documents provided or the information provided is sufficient to establish an H-1B case, they will let us know and allow us some time to respond to that.
Great. So looking through additional questions, my company doesn't have catalogs, brochures, or a lot of marketing collateral. What do I do?
Without marketing information or other information about the company, USCIS will have a harder time determining if your business is sophisticated enough to support specialty occupation in H-1B. Of course, there are ways of overcoming this, and this will require providing any further documentation about your business, and a lot of times this will have to include financial records showing that you have sufficient growth or income to support employment. You can also provide documentation about your projects, so examples of work sites for this particular H-1B position, any projections, or information about your end clients if you are supporting end client employment.
Great. All right, next question. With kind of piggybacking off the RFEs, this person wants to know, are employment consultants needed to provide expert opinion letters? I think that's the question.
At times, RFEs will require expert opinion letters, whether these are specialty occupation letters or expert opinions about qualifications of employees. Depending on the nature of the RFE, we sometimes encourage providing those documents. They are obtained in many RFE cases just to strengthen the case or show that an occupation is a specialty occupation or the employee in fact qualifies for the position.
Great. Well, I think that's all. I think that's all the questions that we have for today. I want to thank everyone for joining. But before you go, we talked a lot about the technology, Natalie, and I just want to reiterate that it can really help improve your H-1B Cap petition process as you're going through it. And if you'd like to learn more, please reach out to Envoy, and we'll give you more details, provide a demo, and all that good stuff. So with that, I would like to thank everyone for joining. Again, this webinar will be sent out, including the slide deck, so you can reference it at a later time. Looks like we just got a good question that came in, so excuse that. So when filing for an H-1B candidate, is there a way to file H-1B noting that as an agency job can change and we can place them in a certain area? Looks like they have several clients, and sometimes by the time the candidate arrives to work on H-1B, the job changes agency.
In these cases, particularly with end client employment, this may be difficult, however, it is doable. What we generally recommend is filing LCAs, or labor condition applications, for several predictable work sites. If you have several work sites in mind where the employee will be stationed or will be working, we will include those in the LCA. And this should be backed by detailed itineraries, which include the job duties performed at each potential work site, as well as possibly end client letters or statements of work when necessary.
Great. And it looks like another question just came in. So how early can the LCA be filed? Can I do it now?
The LCA is valid for 3 years, and you can file it now, however, it will not be valid. The LCA will cover duration of employment for 3 years, and the LCA cannot be filed before 183 days of the start date. So the standard start date for the next year's cap will be October 1st, 2019. So we should be filing the LCA as close as possible to that date to indicate the start date for that, given the 3-year limitation of the LCA. It is encouraged to file the LCA in 2019, either February or March, so that we can provide the longest available duration of employment. All
right, great. Thank you. And I think that's going to conclude the questions. We got another one that just rolled in. All right, so I heard the USCIS will change specialty occupation definition.
So specialty occupation is defined still as it is, which is not the most helpful definition. And there is no word on the change of the definition. However, USCIS is practicing different policies on how to adjudicate specialty occupation cases. While the definition is still the same, USCIS challenges specialty occupation at a heightened level. This is why providing specialized and detailed job duties for positions reflecting their specialized nature is very important in this year's cap.
Great. Hopefully that answers the question. So we have another question. We're just going it over now. No, thank you. All right. Well, that's all. If there are any other questions, please submit them now. Hopefully, we can get to them. So one that just came in: can we hire a candidate with an almost expired H-1B status, but I-140 approved? When can that employee start working?
This question is unrelated to what we are discussing today specifically, but to answer that, which this is probably a very common question. If you have an employee who already has H-1B status, you are free to hire them. Given that this employee has an approved I-140, assuming that he or she is from China or India or other country that does not have a current priority date in the green card process, you may extend this H-1B status for additional 3 years, despite the fact that this H-1B is almost expiring. And your employee may start working as soon as the case is filed, given that this is a transfer.
Great. We'll give it a few more seconds in case there are any other questions. We've been so close to almost ending the webinar, but we've had a ton of great questions that came in, so can't thank everyone enough for that. We'll just give it a couple more seconds. It looks like we got a specific question, but I would kind of about when to open up a case with Envoy, but in that instance, I would say reach out to customer experience or contact us and we can give you more specific details. And with that, so what is the likeliness that USCIS will make an unannounced site visit?
As mentioned in the presentation, the site visits are on the rise, and it has become a policy for USCIS to increase the verification of H-1B employers. Site visits that are unannounced may occur and may occur at a higher rate, particularly for employers utilizing end clients and multiple work sites, employees who are violators of H-1B that were previously found in violation, employers who are H-1B dependents, or meaning the employers who hire more H-1B employees than U.S. workers, and employees who are unestablished as a business and new to H-1B, as USCIS cannot gather enough documentation on them.
Great. Alrighty, and that's where we're going to end it. I know we mentioned thank you again. I just want to mention thank you everyone for joining us today. This webinar and all the great questions that came in toward the end, they will be in the recording, so you'll be able to listen to those, and then you'll also be able to reference the slide deck. So everything will be emailed out to you in the coming days. So please keep an eye out on your email inbox for that. So thank you again for joining us, and have a great rest of your day.